Cominciamo allora la sessione del sabato mattina, che secondo le tradizioni delle giornate gentiliane è dedicata all'attualità del diritto internazionale. Io parlerò 3 minuti per contestualizzare la sessione di oggi e poi lascerò la parola ai 2 interventi della mattina, con l'idea che avremo poi le conclusioni del Presidente del Centro Studi, il Professor Luigi Lacchè, e la conclusione della giornata. Il tema della religione e il diritto internazionale è un tema che, lo abbiamo detto ieri, è stato poco studiato negli ultimi 50 anni, ma si sta assistendo effettivamente ad una riscoperta del tema. E volevo riagganciarmi alla relazione finale di Alessandro Colombo ieri, anche un po' per contestualizzare la sessione di stamani. E lo faccio raccontando di una sentenza che è uscita 2 mesi fa, meno di 2 mesi fa. Meno di 2 mesi fa la Corte internazionale di giustizia ha reso una sentenza in un caso tra Gambia e Myanmar, concernente cosa? Il genocidio o il presunto genocidio della minoranza Rohingya in Myanmar. Cosa c'entra questo con diritto internazionale e religione? In realtà è al centro della questione, perché la minoranza Rohingya è una minoranza di religione musulmana e perché questo caso è stato portato alla Corte da un paese africano distante migliaia di chilometri dal luogo in cui la vicenda si è verificata, contro il Myanmar. Quindi la domanda è: cos'è che lega Gambia, paese africano, a una vicenda che si è sviluppata interamente sul territorio di un paese asiatico? Allora, la religione può essere un elemento che spiega. Nella sentenza la Corte prende per esempio in esame una questione, e cioè se la vera parte che ha presentato il ricorso sia uno Stato o sia piuttosto un'organizzazione internazionale, l'organizzazione degli Stati islamici. Quindi qui entriamo nel vivo della questione, e la questione che ieri Alessandro sollevava, la religione è un fattore di integrazione nel piano delle relazioni internazionali o è piuttosto un fattore identitario, si ripropone pari pari in questa vicenda, perché uno può leggere questa vicenda di un paese africano che fa causa a un paese asiatico per un genocidio in chiave cosmopolita e universalista, la protezione universale dei diritti dell'uomo, o lo può leggere invece come un fattore identitario, la religione islamica che unisce e che giustifica il ricorso di un paese africano, attenzione, sostenuto e forse anche finanziato dall'Organizzazione degli Stati Islamici, per fare un ricorso contro un paese asiatico. E ci sono 2 chiavi di lettura di questo caso, ed è le chiavi di lettura in cui al centro c'è la religione, è un fattore di integrazione, quindi in qualche modo spinge a tutelare la protezione contro il genocidio come fattore, che è la chiave di lettura che l'internazionalista oggi tenderebbe a dare, no? Il genocidio è una vicenda, qui c'è una musica che ce l'ha con me, è un fattore per cui oggi siamo portati a pensare che il diritto internazionale riconosce valori universali in cui tutti gli Stati cooperano per porre termine a una violazione. Oppure in realtà stiamo assistendo a una nuova vicenda in cui la religione islamica in questo caso, è un fattore identitario che porta un gruppo di Stati, non più la comunità internazionale nel suo insieme, ma un gruppo di Stati specifico, ad agire contro un altro Stato. Mi fermo qua perché in realtà è essenzialmente il tema della sessione di stamattina. Noi abbiamo 2 interventi stamattina, uno più focalizzato sugli aspetti procedurali, i ricorsi davanti ai tribunali internazionali, la composizione dei tribunali internazionali, la scelta dei giudici e il ruolo che la religione ha nelle decisioni dei giudici, e abbiamo dall'altra parte una seconda relazione che invece è più focalizzata su questioni sostanziali, nella definizione dei crimini internazionali. in quale misura si riconosce un'importanza al fattore religioso. Quindi sono due relazioni che si integrano e si complementano bene a vicenda. E sono due relazioni in inglese. Questo d'altro canto è anche la Giornata Gentiliana si caratterizza dalla nascita come un evento internazionale e l'uso della lingua inglese è una testimonianza del fatto che c'è un'aspirazione anche a rivolgersi a un pubblico più ampio dell'uso che l'uso della lingua inglese testimonia. So I will now switch into English. So I hope this this insect will leave me in peace. Just for introducing the two speakers of this morning. So the first speaker is Professor Freya Buitens of the University of Oxford. Now, Professor Buitens just started his new position in Oxford the 1st of September, so this is also the right moment to congratulate her for this new appointment. She was before at the University of Leiden and at the University of Oslo. Now, there are many reasons why Professor Buitens has been invited here, and I would say the first reason, more than Oxford, is the fact that she worked a lot on this issue of the identity of judges on the benches of the court. So she's an expert, and she launched a very important volume on this very issue, which has been published 2 years ago by Oxford University Press, on composition of courts, identity of judges, and how these impact on the legitimacy, but also on the functioning of international courts and tribunals. And obviously, as Luigi was mentioning yesterday, we are very glad to keep our contact, Centro Studi contact with Oxford. So in that respect, we are honored to have a new appointed professors of Oxford University here in San Ginesio. The second speaker this morning is Professor Beatrice Bonafè of the University La Sapienza in Rome. And now, coming to Beatrice, here the point is that Beatrice is known San Ginesio, as I know San Ginesio, since many years, because she was for many years professor of international law at the University in Macerata, and we shared a long path together in teaching and making research in Macerata, and I'm happy to see many people who joined the group of international lawyers in Macerata. And she's also here not only because she's part of a small community of people who love San Ginesio and the Centro Studi, but also because she's an expert in international criminal law, having dedicated his first monographic work on the responsibility of the individual and under international criminal law and the link between state responsibility and the responsibility of the individual. With this, my task today is completed, and I simply give the floor to the two speakers, reminding them that we have they have each in between 20 and 30 minutes. So I will be very strict and ask you to comply with this. Thank you, and I give the floor to Freya.
Buongiorno a tutti, mi dispiace ma non è possibile per me di presentare la mia ricerca nella lingua italiana, forse la prossima volta, but I'm afraid I will have to continue in English. I have known the work of Alberico Gentili for many years, of course, but I have to admit to my shame, I did not know San Ginesio. So first of all, thank you very much for inviting me here. I think it's wonderful that you keep this link alive between Oxford and San Ginesio, although I've been in Oxford for 2 weeks and I already fled here, so that's a bit the opposite move from Alberico Gentili. I'm not telling you anything new, of course, if I say that Gentili believed that religion should not play a role in the creation of a legal system, nor in its application or interpretation. And I've started, or the starting point of my paper is this famous quote, "Silete theologi in munere alieno," which in polite translation in English would be, "Keep silent, theologians, when you are not in your own domain," or somewhat less politely, "Theologians, mind your own business." Gentili contributed significantly to the secularization of legal theory, and he's been called one of the first and foremost theorists of non-denominational law. And his idea was that the binding nature of religious rules is not between men, but between men and God. And the value is then that it provides a private link with God and its relevance for the conscience of man, but it is not meant to have consequences in the public domain. We have to protect the sphere of action of public and international law from any interference in religion. Now, funnily enough, and somewhat contradictorily, he fully embraced the doctrine of the providentialist function of commerce, being that God looks benevolently at international economic activity, protects it, promotes it, because this is the means through which God intends to achieve cooperation and peace between nations, between people. That's in some way a very 20th century idea, not the God part, but the idea that you can achieve peace between nations through regulating and stimulating economic activity. You find it, for example, in the founding documents of the European Union. So back then it was perhaps God that had this intention. Now we have the European Commission. I bet Brussels likes to regard itself in that way. But that was just a joke. But to return to the main point, should theologians mind their own business and stay out of law, I have had a look at public international law, more specifically a dispute settlement, to see is religion in any way present there. And of course, if you look at the statute of the International Court of Justice, Article 9, previously the statute of the Permanent Court of International Justice, you find a reference to judges, or the bench, having to reflect the main forms of civilization and the principal legal systems of the world. Now, ostensibly there's no reference to religion there at all, but as I will discuss, it could well be, if you look at the preparatory discussions, that some reference to religion was at least intended, particularly in this idea of the main forms of civilization which need to be represented. So I will be looking at not only the documents, but also the practice, the actual composition of courts, focusing first on the World Court, but then also on some other courts and tribunals. It's of course almost impossible to determine or to provide any statistics, because this information is simply not known. When judges get elected, they are under no obligation to disclose their religion. So what I have done as a further part of my research is to look at actual judgment, actual opinions, to see whether there's any reference to religion there. The counter-argument, of the easy counter-argument, is of course, well, you only look at where religion is expressed, and I will explain the method I use to do so. But it might well be that somebody is influenced by religion, but does not express it. And that is of course true, but that would move or enter into the sphere of speculation, so I decided not to go that far. Now, as you know, in the 1920s, the Advisory Committee on Jurists started drafting what would later be the Statute of the Permanent Court of International Justice, which was the judicial organ of the League of Nations. And as I already mentioned, Article 9 of this statute says that the members of the court represent the main forms of civilization and the principal legal systems of the world. Now, if you look at the discussions among the advisory committee members, the idea was mainly that they wanted to create a bench that was palatable to the largest number of states, acceptable, but at the same time sufficiently independent, sufficiently representative, so that it would be authoritative and powerful enough to function. a large part of the discussion focused on how the great powers should be represented, who the great powers were in the first place, but also how it could be ensured that they would have a judge on the court. And you can see that this concept of civilization was very Eurocentric. The idea was, of course, that, or the thought behind it was that judges who were trained in the European Western legal education were superior intellectually. And when I say judges, of course, I mean exclusively men. It was not envisaged any woman would ever serve on the court, and that was also the case until the 1990s. Now, this might be less palatable today, but this is simply how these discussions occurred. There was, however, a Japanese representative who put forward what looks like a rather modern discourse on civilizational pluralism. Of course, Japan put itself forward as one of the 5 powers. It regarded itself as superior to other legal systems, very influential, but of course there was no doubt that it was not a Western power, so the discussion then focused on how should we ensure representativeness. The US and UK representatives put forward this formulation of different forms of civilization and juridical systems which exist among the members of the Society of Nations. No reference to religion was made. France then said, well, there has to be geographical representation, and we have to identify countries that are centers of civilization, and then one such center should be able to deliver a judge. Again, perhaps unsurprisingly, no reference to religion. This was then adopted by the Belgian representative who was chairing the committee, and he, Baron Descamps, suggested changing the phrase to the main forms of civilization and the principal legal systems. There's funny things going on with the microphone. In order to avoid discussion. Of course, that didn't work. There has always been a lot of discussion about this clause, also about the need to represent different languages, which was put forward both by the US and Spain. But the only real reference we find to religion was again by this Japanese representative who referred to the sphere of action of the court, which would include all nations, races and religions, and the need, therefore, that the psychology of the various peoples must be understood. And I'm quoting here, Europe and America have a psychology based on Christianity, while the psychology of the Far East is based on Buddhism, Shintoism, and Confucianism. Now, this was not accepted, as in others were quite intent on removing any reference to religion, and then the US representative, Mr. Root, said, well, you know, this is all part of the habits and customs of people more broadly, and religion fits under that definition. Now, the committee did explain why this reference to forms of civilization was, in addition to the requirement of principal legal systems, was necessary. And the idea was that they wanted to capture national and continental tendencies, which must be considered different systems of legal education. So in sum, I think we can conclude that in the drafting of this first and to this day arguably most authoritative statute, religion did not play a big role. This statute, after the committee finished its work, then went to the Council, the Assembly of the League of Nations, and again religion was not really discussed when they looked at how the judges should be appointed or should be selected. The only reference we find there is that there was a recommendation by the Joint Foreign Committee of the Jewish Board of Deputies referring to the need to have experts, additional experts, where issues of religious law were to be discussed within the context of the minority treaties. That seems to indicate, if you need additional experts, that by default the judges were not expected to be experts on any matter of religious law. So far, this, at least on paper, squares with Gentili's desire to keep theologians out. Now, as you all know, law on the books can be very different from law in practice. So in the next part of my research, I looked at what actually happened in practice, because of course, judges are people. You cannot really distinguish the person as an adjudicator from the person with inevitable personal beliefs, ideologies, and religion. And in this regard, I looked at mostly final decisions, so I didn't go through every order that was ever issued, and I looked to actual references to texts, say the Quran, the Bible, the Torah, to specific religions, references to Hinduism, Christianity, Islam, or to specific persons, Abraham, Jesus, Muhammad, etc. If people are interested, the complete list is about 50 terms. You can email me and I'm happy to share that. I did not look at general references to morals because I thought that was a bit too broad and too vague. And I only looked at actual religious rules, or the idea that rules should be interpreted using religion, not to mere mention of, say, the burning of the Quran, for example. And to give you a sneak preview, there is very little explicit reference to be found. There's almost no decision by full benches where they rely on religion. More can be found in individual opinions and separate statements. The only exception, as I will explain in a minute, is in human rights courts, where you do find more references, perhaps unsurprisingly. So at the ICJ, I could actually only, the International Court of Justice, I could only find one reference where the court actually relied on, sort of fleetingly relied on religion, which was in the Tehran hostages case, which, as some of you might remember, was the case where the Iranian revolutionaries occupied the US embassy in Tehran for over a year, kept people hostage. And when the court dealt with this case, it referred to the inviolability of persons of diplomatic agents and the premises of diplomatic missions, which is one of the very foundations of a long-established regime, including informed by the traditions of Islam, which made an important contribution. However, when we look at the over 1,200 declarations and separate and dissenting opinions appended to ICJ judgments, there are 13 individual opinions which actually, again, not very many, but there are at least 13 which in different cases referred to religion. And I'll just give you 3 recent examples, and the first one, you stole my thunder, Paolo, by referring to the Gambia versus Myanmar case, because there's actually 2 there. Again, this is a case where the Gambia sued Myanmar for the alleged genocide on the Rohingya minority, the Muslim Rohingya minority, and that is allegedly committed by the Buddhist majority. And this was a kind of actio popularis, so the Gambia does not claim that its citizens are personally injured, but it brings this claim on behalf of the greater Muslim community. And the Brazilian judge, Cansado Trindade, who unfortunately passed away earlier this year, talks about evil and cruelty in human relations and goes back all the way to the book of Genesis. The German ad hoc judge Klaus Kress, in the same case, refers to the work of Georges Abissab and, among other things, observes that the concept of such an actio popularis bears a resemblance to an Islamic law concept, which is the Dawa al-Hizbah. And this is not the only recent case in which references to religion were included. For example, in the Immunities and Criminal Proceedings case, which was Equatorial Guinea versus France, where France, among other things, seized a building in Paris where they claimed it was owned by somebody they were investigating for fraud, whereas Equatorial Guinea claimed that this was a diplomatic mission. And there, in his dissenting opinion, Judge Bandari, the Indian judge, went all the way back to the Roman times and talked about the inviolability of priests of the College of Feriales who conducted diplomatic negotiations on behalf of the Republic and had certain privileges and immunities as a result. Now, I do realize this is going all the way back to Roman times is scraping the barrel a bit, but this is what you have to do if you want to find explicit references to religion. Now, I also looked at the Tribunal Law of the Sea, nothing to be found. There is one interesting case in the Permanent Court of Arbitration, which, as you may know, is neither permanent nor a court. It's a system of arbitration where people are appointed for one particular case, and then they go back home to whichever other jobs they have. And in the Eritrea-Yemen case versus Yemen case, which was a boundary dispute, the tribunal based its award on sovereignty partly on regional legal traditions. And it talked about the historical realities which characterized the lives of the populations on the both eastern and western coasts, which is rooted in common legal traditions and for several centuries has been in practice among the populations around the Red Sea, partly because they were all part in the 19th century of the Ottoman Empire. So far, this is all still, we're in the realm of the different legal systems. But the tribunal then continues, referring to the basic Islamic concept by virtue of which all humans are stewards of God on earth, with an inherent right to sustain their nutritional needs through fishing and to trade the surplus of such fishing, and how this was part of the local rules that ought to be taken into account. The conclusion was then that the fundamental moralistic general principles of the Quran and the Sunnah may validly be invoked for the consolidation and support of positive international law rules in their development towards the goal of achieving justice and promoting the human dignity of all mankind. So you have a direct reference to religious texts, the Quran and the Sunnah, but they are subservient in a way to public international law rules. So it's for the consolidation and support of the positive law. It's not a source of law in and of itself that is separate. If we then look at the International Criminal Court, so far there have been no explicit references to religion as a source of law or as an inspiration to judges that I could find, but where you do find quite a number of references is in the European Court of Human Rights. And I've categorized cataloged these into 4 types of cases, and the first category are the headscarf cases. And the idea is, can the government regulate the wearing of a headscarf? And the main idea is that in a democratic society, a state can indeed place restrictions on the wearing of an Islamic headscarf if it is incompatible with the aim of protecting rights and freedoms of people. And that has to be balanced against the precept laid down in the Quran that women, or in certain interpretations, that women have to wear a headscarf in public. So you have that obligation in the Quran on the one hand, and you have the idea of gender, or the principle of gender equality on the other. And in each case, those 2 principles should be balanced. And again, similar to what I just said about the Eritrea versus Yemen case, often the positive law obligation, the gender equality obligation, will prevail over the religious obligation, but not always. A second category of cases where you find this same balance between religious obligations or religious beliefs and the possible conflict with, in this case, the European Convention, is in a number of hate speech cases, where the court said, on the one hand, it's difficult to declare your respect for democracy and human rights, while at the same time pushing for a legal regime based on Sharia law. And the court considered that Sharia, which reflects the dogmas and divine rules laid down by religion, diverges from convention values, so not merely the gender equality ones, but also with regard to criminal law, for example. And in certain cases, this actually warranted the dissolution of a political party if that political party was had real potential to seize power and to actually impose Sharia law. On the other hand, if you have expressions that seek to spread, incite, or justify hatred based on religious intolerance, you do not get the protection of free speech under the Convention.
But there has to be a place for pluralistic debate. So if you're not pushing for a violent overthrow, if you just really believe Sharia should be the law of the land, but you're not claiming that we should get there through a violent revolution, that would again be covered by or protected by the convention. So you see, it's a very tricky balance, and it has been, or individual judges have criticized the way that the court has conducted this balancing act. And in another set of cases that you find before the court, they deal with apostasy, and in particular whether Muslim people can change religion, which under certain interpretations of Islam is actually a criminal act. So you can convert, if you're Catholic, you can convert to Islam, but not the other way around. And there, individual judges have said, no, this actually violates the right of freedom of religion of Muslim people. They have to have the right to change religion. And interestingly, what these judges have done is then to support their position by references to the Quran on the freedom of religion, and saying that there's no verse in the Quran that says that conversion should be punished, conversion in any direction. The last set of examples relates to property, and there have been a number of cases where the court denounced marriage traditions which put women at a financial disadvantage, and then one judge at least said that the court actually failed to understand Islamic law, and he argued that that there are a number of provisions in the Quran that do bring that financial balance between the male and the female spouse. And what this judge then did was accusing his own court of ideological activism. And I think that is one of the reasons maybe why courts stay away from referring to religion at all, because as soon as you set a foot wrong, you could be branded an activist and no longer a reliable judge. Now, I have done the same exercise with regard to the Inter-American Court of Human Rights. Nothing to be found in judgments. Oh, I thought you were looking at me as in that I have to wrap up.
You have 10 minutes.
I'm not finished yet. And strikingly enough, the same judge who, Cansado Trindade, who Brazilian judge on the ICJ, previously was a judge and the president of the Inter-American Court of Human Rights, and he's the only one who peppers his opinions with references to Genesis, with references to Ecclesiastes, and particularly to the Confessions of Saint Augustine. Other judges in the Inter-American Court don't do that. The bench doesn't do that. So on the whole, you find very few references, and in that regard, Gentili, I would say, got what he wanted. Theologians or religion seem to stay out of international adjudication. But I would like to return for 1 second to my statement at the outset. How realistic is it that you can really separate the religious beliefs of a judge from the adjudicatory activities of a judge? And I would say maybe it's in this, these hallowed halls, it's even like swearing in church, but was Gentili entirely right to say that religion should play no part whatsoever in lawmaking and law interpretation? So as I said before, a person's origin is not indicative of religious beliefs. It's a private matter, often we don't know. But, for example, if a judge hails from Italy, it's not necessarily a Roman Catholic. If a judge comes from India, you can't be sure it's a Hindu. There are no statistics on this, and there's a serious lack of information. So would it perhaps be more correct to say that Gentili might not have been right? We simply don't know. We simply don't know to what extent religion plays a role. And should religion play a role? Should we take it more into account? Should we anticipate that there will always be an element of religion, even in cases? And if we recognize that that is the case, the question may therefore become, should we actively search to create a kind of representation that we are currently looking for in the context of gender or nationality? So, for example, judges do have to have a certain geographic representation. You have judges from all over the world. And there's a big debate whether courts should be more gender balanced. And the idea behind that is that there's two ways in which diversity, broadly speaking, two ways in which diversity might play a role. And the first one is that if you have your identity matters in how you take a decision. Who you are, or who a judge is important. And there has been, and Paolo was so kind as to refer to a project that I conducted in this regard. There is a lot of evidence that, for example, criminal tribunals, and I'm thinking of the ICTR and the ICTY, only started paying attention to rape as a strategy of war as soon as there were women on the bench. The same argument has been put forward that investment arbitration tribunals only really start taking into account global South issues with regard to development, issues what investment really means on the ground, if you have a judge from the global South. So does identity, and that includes religious identity, may that change the outcome of a case? That's the first question. And the second one is, even if it doesn't change the outcome of a case, even if you regard judges as machines, a bit like Montesquieu's bouche de la loi, you feed in the facts and a judgment comes out, no matter who that judge is. Even if that is your approach, you still have the element or the perception of the recipients of the judgment, which can be the respondent state or the respondent population, who may or may not feel that they have been judged by their peers. And in that regard, does perception matter in terms of the authority of a decision? Does it matter in terms of the legitimacy of a decision? And will it eventually matter in terms of compliance? Now, looking first at the first element, will it actually affect, does religious identity of the adjudicator affect the decision? Again, it's very hard to say yes or no. As a source of law, I think we can be quite clear it doesn't. Even in the examples that I gave, religious texts were referred to as context, as understanding a dispute, maybe as incorporated in the general principles or the domestic law, but not as a source in and of itself. But in terms of perception, and again I admit this is very hard to prove, but in terms of perception, it would indeed seem to matter. If the European Court of Human Rights says that a state was right to outlaw the wearing of headscarves, if you actually have, and these cases were often against Turkey, if you actually have a Turkish judge agreeing with that, yes, it matters for how this is viewed. This is not a new idea. I mean, in the Magna Carta already they established this idea of you have to be judged by your peers. And in these cases, it can matter if that peer is of the same religion as, say, for example, in these headscarf cases, as Turkey. Through my examples, I hope you've understood that I say that different courts require different types of diversity. I don't think religion matters that much in the World Trade Organization, for example. But it does matter in human rights cases. It does matter in cases like the example that I gave about the International Court of Justice. And again, this is not a revolutionary idea. It's in a way very similar to the US position that I started with, that the court should be able to understand or be in sympathy with all types of cases that are being brought. Or the Japanese representative in the advisory committee of jurists who said that the psychology of peoples should be understood by the court. And then in that sense, considering religion is an element of culture that arguably should also be understood and represented on the bench. Now, how you will achieve that representation, particularly bearing in mind that judges don't disclose their religion, is a different matter. But to finally answer the question set at the outset, are theologians minding their own business? Is religion completely absent in international adjudication? I don't think so. I don't think it was realistic in Gentili's time, but I think even in our times, it is not realistic to expect that. I don't even think it's desirable to expect that. I think it's often needed, a certain level of understanding is needed to take a good decision, That doesn't mean this will necessarily be expressed in the judgment, but it doesn't mean it's not there. And I think in that regard, we should look at that statement by Gentili and understand it in a much more nuanced way than just a yes or no question. Thank you.
Many thanks, Freya, also because 30 minutes sharp, really. Just two observations. One, the first is a personal recollection. Professor Bytens mentioned a couple of times Professor Judge Antonio Cansado Trindade. I would just remind that, and perhaps Pepe remind also this, Cansado Trindade was here in San Ginesio 4 years ago, and I remember very well having lunch at Pepe's house on the terrace with with Judge Antonio Cansado Trindade and his wife, and he was really fascinated by San Ginesio, by the fact that there was a Gentili center here. He spent like 1 hour looking at all the books of the library of the center. So it's, thank you for mentioning also Judge Cansado Trindade. And the second is, let's start a bit the discussion, and I have a question to raise here. So you raised 2 points. The first is, does perception matter? And the second is important to have religious references explicitly in judgments or decisions of international courts and tribunals? I have the impression that the two aspects are related somehow. So if states bring a case to a court, and what triggered the decision to bring a case to the court is related somehow to religious matters, perhaps states expect some references also to religious aspects in the decision of the tribunals. The impression I have is that so far religious matters has not been a real trigger for bringing a case to the court. Perhaps the Gambia case is one of the first that comes to my mind, but perhaps I'm wrong. And so I'm wondering whether if we accept the idea that there is nowadays a tendency of states to rely more and more on religious aspects as a factor of identity, or in any case as a factor of allegiance link between them, might this influence courts and tribunals to rely more on this aspect also when explicitly basing their decision on international? So does this may have an impact on the way courts and tribunals refer to religious matters in their judgment and decisions? So now it's the turn of Beatrice. So this is for the discussion. I think we don't need to, and we will open a discussion later on if we have the time. But I will give now the floor to Beatrice.
Paolo, thank you very much. Let me say a few words of gratitude and mention the exquisite hospitality of Pepe. It is not to be forgotten, and San Ginesio in general, because all the inhabitants and those involved in the center are always present here. It's a pleasure. Paolo already mentioned that. It brings us back in time and memories for the internationalist group, and we cherish those moments. And last but not least, nowhere else you wake up in the morning in a hotel room and you hear someone, a cello, rehearsing Bach's suites. But I turn to the object of my presentation. So the effort I will try to make is to give you my thoughts on the relationship between international law and religion. I should say more specifically international criminal law and religion, but I will try to be a little broader than what I thought, and I changed a little bit my presentation that's why I would like to start with a connection with the question I asked yesterday and try to bridge the two sessions, the historians and international lawyers session. I asked that question because I was really trying to better focus the assumption I started from. And I think there are two standpoints that should be kept separate from the very beginning. The first one has been largely mentioned yesterday, secularization. So the gradual separation of the foro interno, foro esterno, the separation of competences of theologists and jurists, division of labor between them, the identification of different fields of theory, of different objects of study. If you want, this is what we call scientific specialization today. I would say, I mean quite easily, that today this separation of the domains is the product of positivism, that law and religion are separated, and I use the term separated, not excluded. This is different. Religious cases, religious argumentation can be used by lawyers, but I think the first approach is to look at the two fields, the two scientific fields as separate. But religion, and I will better qualify the notion, can clearly be the object of legal rules. And this was basically my starting point when I started reflecting on this matter. And I would not say that religion has been removed from law, not entirely. It can be taken into account. It can make the object of the law, but the separation is still there. And these are two aspects, I think, that should be distinguished. So one aspect is the field of study, the specialization one has. I deal with law, I deal with religion. It does not matter. It does not mean that religion cannot be the object of legal rules of the legal order. And this implies two things, or better, three things. One, the religion is clearly, or better, lawyers would not step into religion discussion. Not today. I think what has been described by Vincenzo, for example, a discussion of religious matters in terms of religion by lawyers today would be hardly expected. There is no intrusion in that sense. But the opposite is absolutely current. Lawyers would take into account religious cases, religious argumentation, religious aspects when they deal with legal rules, when they interpret legal rules, when they take legal decisions. And so once we have removed this aspect, the term religion can be understood basically in two different ways. As part of the process, and Freya would tell me this is the correct interpretation of what she has just told you. So part of the process of the bigger picture, you have composition of courts, identities, and so on. And this has to be taken into account when you study the outcome, law as the outcome of this process. And the other way in which you can understand religion is just as a mere object of existing rules. This is what I tried to do to complement the first the first intervention. So I would start from the first point, secularization, separation is there. Does not mean, second point, that there is no interaction between the two. And my purpose is to look at the rules, the existing rules, and see whether this interaction reveals still a separation or an intrusion or other forms of interaction between the two fields. Now, I should have, and I will basically focus on international criminal law, but I will say a few words about human rights law. Why? Because human rights law is possibly the first field of international law you may think of, and I guess the result of the previous analysis is a confirmation of that. You may think of when you start a research concerning religion and international law, for the main reason that you do have provisions protecting religious thoughts, religious beliefs, and so on. It is not an easy task, but I mean, there you do have something. So I would basically say three things about human rights law. First, religion is present from a theoretical point of view there. Just to mention a recent book on human rights and religion, le droit international des droits de l'homme est laïcisé, en ce sens qu'il a été construit sans référence fondatrice à l'univers religieux. But the religious universe is there. It is regarded by some as being at the very origin of human rights because they make reference to very general notions such as justice, dignity, equality, and so on. So it's present in that sense. But it is also present because of the freedom of religion and the specific articles in the Universal Declaration, the Covenant on Civil and Political Rights, and so on. On freedom of the religion, that's one of the things. But religion is there and is not protected as such. It is protected as freedom of religion. And this brings me back to what was explained yesterday in the framework of Alberico Gentili's analysis, La Libertas Religionis. This is the object of human rights law, not religion per se, but the possibility of professing different religions. So it's pluralism that is the object of human rights law today. And the third is just a reminder of one of the cases, one of the famous cases of the European Court of Human Rights, which somehow comes confirming this approach. We can criticize, it has been criticized as a typical French approach, but this is what the court said in 2009 in the Lauzzi case versus Italy. It was the religious symbol present in public institutions. The state's duty, and I quote, of neutrality and impartiality is incompatible with any kind of power on its part to assess the legitimacy of religious convictions or the ways of expressing these convictions. In the context of teaching, that was the issue, neutrality should guarantee pluralism. So this is just to give you three very, very broad hints, the way in which religion is part of human rights law today under current international law. But mainly what I did is to have a look at international criminal law. First, as Paolo mentioned before, it's part of my expertise. And second, it is the other field of international law where you do have explicit references to religion. Just a few of them, but they're there. So what I did at the beginning, I took some very general books, textbooks, manuals, and went at the very end at the index and checked for religion or religious something or religious group. Why? Because in the table of contents, you don't find anything. There's no chapter, no section. Generally, there's nothing about international criminal law and religion. the mention, you do find something, very, very short passages concerning genocide, mainly, sometimes war crimes. I'll come back to that. So it was a hard research because the matter is not really analyzed and systematically studied. So my presentation is just a first attempt to give you an overview of the legal rules that do tackle religion and that deal with the religion under international criminal law. It will be a systematic account of the main rules. But before doing that, I would just recall the two aspects of international criminal law, so that I can quickly get rid of procedure. There is a growing important part of procedure in international criminal law. You think of the rights of the defense, a fair trial, the victims, protection of victims, and so on. So in that part of international criminal law, you may find something simply because human rights apply. And this is generally recognized today, not just under the ICC statute, International Criminal Court statute, but also in the case law of international courts and tribunals. So through human rights and the rights of fair trial, you may have the protection of religion with respect to witnesses, victims, the participants in the trial. Especially non-discrimination. This would be non-discrimination on the basis of religion, for example. So you may think of a number of cases in which this may be relevant. But basically what I did is to look at the substantive definition of core crimes. When I say core crimes, I mean crimes under customary international law, and this is important for the conclusion. Customary international law is, unwritten law binding for all international subjects independently of the presence of those rules in a treaty or in an international legal document. Aggression is the first that may come to your mind because there may be a connection with just war, the reasons for war, and so on. But nothing like that is to be found today under current international law. One of the main experts on the crime of aggression mentioned, and this is Klaus Kress, and I quote that some just war theorists have offered lengthy lists of just causes that contain a variety of high implausible entries, such as the conversion of people from one religion to another to justify recourse to use of force. But under current international law, the prohibition of aggression is totally independent of the reasons that the party may give. Just to mention Article 5 of the General Assembly resolution on the definition of aggression, it says that no consideration whatsoever may serve as a justification for aggression. The same if you look at the ICC elements of crime, the detailed list of the elements that each crime should have. Nothing can be found with respect to Article 8 bis, which is the article dealing with aggression. So, no religion under aggression. War crimes, something more. They do afford some protection to the freedom of religion. Again, I won't go into the details, but it's important to remember that war crimes are basically divided into big subcategories. One that protects specific groups, people, and other that deals with means and methods of warfare. And you do find in both groups something dealing with religion and some kind of prohibition that is meant to protect religious groups, religious institutions, or simply religious beliefs. I'll give you just a couple of examples. level of medical personnel, religious personnel should be identified and deserves special protection under Geneva law. Prisoners of war should be respected as far as their religious needs and duties are concerned. The civilian population should not be discriminated on the basis of religion, and so on. As far as the means and methods of warfare, it's something that you may be aware of, the prohibition of attacks with respect to religious institutions. You cannot launch an attack with respect to a church or a mosque or other institution of that kind. No willful damage of places of worship is allowed, and so on. So what you do find under international humanitarian law is a number of provisions that would protect the possibility of, again, having a certain religious belief, of exercising certain religious duties, rights, but you don't really find the protection of one religion against the other. So, of course, no discrimination in that sense is made. The other way around. The general principles of humanitarian law would rather be the principle of non-discrimination in this case. Now, genocide. Genocide is possibly the crime where religion is more present, because you do find religious groups in the definition itself. Genocide is the prohibition to destroy 4 groups, not more than that, national, ethnical, religious, and racial groups. And there's been a long discussion, even in the case law, on the definition of these groups and the reason for their inclusion in the definition of the Genocide Convention. The definition has not changed. It was included in 1948 in the convention, and all the statutes of international courts and tribunals do include the same. So it seems that genocide may protect religion in a different way. It concerns the group as such. The Genocide Convention has been regarded by some as a human rights treaty. It is different from a human rights treaty, at least to my opinion, because it does not concern individuals, but rather groups. Its purpose is really to prevent and punish the destruction of certain social groups. And when it comes to religious groups, the problem of the definition was to understand what the convention really meant. The big debate, to make a long story short, was between an objective interpretation and a subjective interpretation. The judges started by interpreting those groups as stable, permanent, scientific group, which was clearly not the case. If you think of racial groups, this is not the case. Religious groups may appear at first sight as more stable than others, but you do have flexibility in the definition of membership also with respect to religious groups, so this may be a problem if you understand the definition as a flexible one. The best outcome was to find a balance between the two approaches and recognize that in the end, it is a social construct. It is a social dynamic that leads to the separation of the people into different groups that would recognize each other on the basis of national, religious, ethnic criteria. So in the end, the definition is not a definition of a religious group stock or identified, but by some permanent and stable characteristics, but it's more a dynamic definition of the social group. But what's important in the end is to understand that this group is not protected again as such. It's not the protection of the Muslim group in the Gambia versus Myanmar case. It's not the protection of other groups in other genocide cases. But what has been underlined is the fact that what's intolerable, what is not accepted by international criminal law is the destruction of the group as such. That international criminal law is the part of international law that attaches the most severe consequences to certain prohibited conduct. It had to be restricted. Only certain groups had to be protected. And despite attempts to broaden this list of groups, this was not done, at least with respect to the Convention and the text of the statutes. I would briefly mention crimes against humanity, and I'm checking with Paolo if, okay? Crimes against humanity, again, you don't have explicit reference with one exception, persecution, which is important. I kept that for the end because I think persecution is the perfect example of this non-discriminatory principle that is behind the protection of religion under international criminal law. And persecution is prohibited as a widespread or systematic attack or violence or deprivation of fundamental rights against any, I quote, identifiable group or collectivity on political, racial, national, ethnic, cultural, religious, gender, or other groups. So religion is there. Crimes against humanity are different from genocide because they're not meant to protect a group, a social group. They want to protect humanity as such. They want to exclude or prohibit attacks on membership in humanity as such. So a person should not be targeted, should not be deprived of their fundamental rights in a much more general way. And persecution is the fact that one group is identified, selected, targeted with a discriminatory purpose. Sterilization campaigns, adoption of discriminatory laws, or assimilation programs, and so on. These are detention, imagine detention of a group of people. All these are activities that would qualify as persecution. So religion is one of the grounds on the basis of which persecution can be found, and the crime can be punished under international criminal law. It has been summarized as the violation of the right to equality. So if persecution could be briefly summarized in one expression, this is what has been said. Other crimes against humanity, I won't be long on that. There's a residual clause in the end. Other inhumane conduct may amount to crimes against humanity, and there we may find religion. But basically, it's this notion of non-discrimination that struck me as the unifying concept. At least this is my reading of existing rules. When religion finds a place in international criminal law, be it genocide, crimes against humanity, or even international humanitarian law, the purpose is always the same, is non-discrimination, is protection of the equal dignity of one group when compared to the others, is the protection of pluralism, of diversity. And this confirms to a certain extent what has just been said by Freya, the fact that in case law you hardly find religion in the legal argumentation of judges as such. I think really this is something that would, and this is to conclude, lead me to say that at least as far as international criminal law is concerned, the separation of law and religion is concerned as far as the first standpoint is concerned, secularization. Religion is actually part of international criminal law, but not a protection as such, which confirms the primacy of law over the religion in a certain sense. The fact that religion or the protection of one religion would not be acceptable at the detriment of other groups or other religions, somehow justifying the fact that the two fields are separate, but that juries would indeed do their best to maintain this pluralism and equality between religions. Thank you very much.
Thank you, Beatrice, also for respecting the temporal limitations of 30 minutes. And my question to you is, I fundamentally agree with the idea that international criminal law essentially aims at the protection of diversity. But at the same time, I had the impression that you seem to put genocide and crimes against humanity on the same level when it comes to the relevance of the religious factor. And this reminds me of the debate that took place after the Second World War, whether international criminal law should focus more on genocide or crimes against humanity. So the debate between Lauterpacht and Lemkin and the book of Philip Sands on East-West Street, I have the impression that religious factor weighs heavily when it comes to genocide. And for Lemkin, obviously for him it was the persecution of Jews during the Second World War, which was the core issue and the core reason behind international criminal law, while Lauterpacht stressed the importance of protecting the individual as such, not the individual as belonging to a group, including a religious group. In that sense, I have the impression that, and obviously there is always this duality in international criminal law, the duality between crimes against humanity and genocide, whether their belonging to a group should be regarded as a relevant factor, or whether it is the individual as such which has to be regarded as the main element. So I wonder whether this element should not also be taken into account when assessing how the description or how the development of international criminal law reflects also the importance according to the religious dimension. Passo all'italiano perché ora ho un dubbio. Non mi sono informato sull'organizzazione. Che facciamo? Dibattito? Ok, d'accordo. Quindi io direi un coffee break di un quarto d'ora per rimanere nei tempi e chiudere un quarto a mezzogiorno per avere poi il tempo di... Perfetto. Allora, coffee break. Allora, riprendiamo sapendo che i tempi ormai sono ristretti, perché abbiamo 20 minuti per il dibattito e poi darò la parola al Presidente del Centro Studi, Professor Lacchè. Quindi ci sono interventi. Ho chiesto alla professoressa Baiten se era possibile fare la domanda anche in italiano. La professoressa capisce l'italiano. Come sempre, chi vuol fare la domanda in italiano deve parlare lentamente. Questo fa parte delle... e non ci rendiamo mai abbastanza conto di quanto parliamo velocemente, a cominciare da me. Allora, io ho già formulato 2 domande ai 2 relatori, ma ci sono domande dal pubblico. Se non ci sono domande vuol dire che non è piaciuto, no? Scherzo. Do you want
to have more information about yes, to have more information about the question of apostasy and conversion, because I studied the phenomenon during the early modern age. I'm interested on this topic nowadays. Thank you. If you have more information about this question.
I wonder whether we should... Scusatemi, io penso che potrebbe essere una soluzione quella di raccogliere, I don't know how you feel more comfortable, se preferite all together. Yeah. Ok, quindi raccoglierei altre domande e utilizzo il mio ruolo di antico supervisor di una serie di persone qua presenti per notare che ci sono anche dei postdoc di diritto internazionale che sono invitati a fare domande, o degli anziani laureati in diritto internazionale che sono interessati. Rachele.
Okay. Thank you both for your really interesting interventions today. And I have a question for Professor Buitens with regard again to the, let's say, to the idea of symbolic value, let's say, so of diversity at the bench. Do you think that in reality maybe it could matter more a democratic value more than a perspective of with regard to the representation of judges at the bench, before an international bench? So,
sorry, I don't understand. It matters more as a what?
As a representation of judges. So if the religious element can have could matter more in terms of democratic value more than as for a perspective of the representation at the bench. And with regard to the parallelism that you made between the religious element with, for example, other elements that have been quite discussed internationally, as for example the gender element, do you find that this parallelism is maybe considering that the gender element, for example, is an objective element? On the contrary, we could say that the religious element is a cultural one and it's a bit more fluid, let's say. So how can we compare them in terms of representation of the bench at the international level? So, thank you.
Raccoglierei un'ultima domanda. Cecilia.
Thank you very much. Beatrice, I have a question for you about the Lauzzi case. You said that that case can be seen as a judgment which aims to protect pluralism. Do you think that actually the Grand Chamber judgment could also be seen as an attempt to protect national identity and Italian culture more than religious pluralism? by making reference to the margin of appreciation as a way to leave room to the national identity. Thank you.
Do la parola alle due relatrici. Perhaps we can change the order and Beatrice can start.
Could be quicker. Okay, let me start with Cecilia's question. The correct answer is that I don't know. What I mean is that there was clearly a different approach. The first decision was criticized, but what we have to take into account is also this important margin of appreciation, criterion that is used by the European Court to balance somehow different identities and so on. So this has to be taken into account, brought into the picture. So on the one hand, there is the attempt at ensuring diversity and pluralism. On the other hand, it should not go at the detriment of a certain margin of freedom of states. So I think that was the real challenge in that case, and that justifies possibly the two different approaches. And I briefly try to come to Paolo's question, and I thought a lot about the West-East Street book and these two let's say, different perspectives, but my feeling is, or let's say like this, my attempt was to go beyond this divide, and rather than see the protection of groups, the protection afforded by genocide on the one hand, Lemkin, and the protection of humanity, individual rights, Lausanne-Pact on the other hand, what I tried to give you as an account is one that sees the connection or the underlying connection between the two, that focuses on the social dynamic, the importance of protecting the dynamic, be it one group dynamic or just one of discrimination of individual. And I think this is what international criminal law tries to take into account today. Not so much opposing genocide and crimes against humanity, but trying to insist on the common protection of the two. There's been long discussion on the crime of crimes, the gravest crime. Is genocide more serious than crimes against humanity? When it comes at sentencing, this is extremely important because you have to decide different sentences. So I think in the end, the purpose is not really to classify crimes, but to ensure that the most serious breaches are punished, if possible, prevented. And this is something that I forgot, but the analysis of international criminal law is also important because it tells you which are really the core elements, the core aspects of protection. It's the field of international law that would attach the gravest consequences, and therefore had really to look at what's important. And this is something to be taken into account. I would say a very last word, something for Freya. It's just a thought. This diversity is procedure and the rules of obtaining a collective decision, the way of balancing different identities in a common outcome It might be the judicial decision, or it can be the decision of an organ, collective organ. So, is procedure there somehow to obliterate the individual identities of the members? Have you taken that into account? Thank you.
Okay, thank you for those questions. I'll start with Paolo's question. I don't think it's new that religion triggers disputes. I think what is new is that these disputes actually make it to international courts. Does that mean states expect more references to religion? Well, it's hard to say. I don't think you can say yes or no. And for all states, maybe some do, but an important number of states do not, very much not so, and would be completely, would find it completely abhorrent if courts would start frequently referencing religion. I think that's mostly Western states where the separation of church and state is really, perhaps a fiction, but one that is very carefully maintained. I think judges, as in lawyers more broadly, we are trained not to mention religion, not to rely on religion, to focus on the law. So whether we do not refer deliberately to religion, or maybe even subconsciously, the fact is we don't do it. And I think there's very good arguments, and Gentili made some of them, not to do so, but it doesn't mean it's not there. And there's a fascinating line of scholarship where that argues that judges actually decide, when they are faced with a fact pattern, they first decide what the outcome should be based on their personal, including their religious beliefs, and then they look for arguments in the law to support what they have already decided should be the outcome, which of course makes all of us feel very uncomfortable, but I think there's a grain of truth there. Should it influence the court? I think in terms of context, yes. I think judges need to know about religion, and the best way to do so is to ensure or promote or hope for that you have a diversity of religious backgrounds, because it will lead to a better balanced decision, a better understanding of a dispute. And secondly, I think it will help with a decision of a court to be seen as legitimate and therefore better complied with. However, I think it entails a risk. Courts derive their authority, they derive their power to decide from positive law. The moment they venture beyond positive law, they actually don't have the competence, both the competence in terms of the jurisdiction, but also the competence in terms of ability, and they open themselves up to criticism and possibly a tug of war with religious leaders who say, but we have the Vatican has the exclusive competence to decide what Catholic doctrine should look like, and I think that would undermine the value of a judgment. Regarding the cases on apostasy, there have been a number. As far as I know, all of them dealt with Muslim people who wanted to convert to something else. I have not come across any cases with Catholic people who were somehow barred from changing religion. All of these were decided based on grounds of freedom of religion under the European Convention, where usually the convention was seen as prevailing over any possible rule of religion. And indeed, those 4 judges that I mentioned in the case of FG versus Sweden actually said, well, what we say is what the convention says, but is also what the Quran says. And I think it's important, and again, that's why I do think that the intensity of the judge is important. So these judges were Aneta Zimele, Judge De Gaetano, Judge Pinto de Albuquerque, and Judge Wojciech. So it's first of all good that it was a collection of heavyweights on the court that said this in their separate opinion. But for example, Judge Zimele is not only a law professor, but she was a professor on the Constitutional Court of Latvia and is now a professor on the Court of Justice of the EU. So these ideas travel with the judges, so you can expect that this is a line of thinking that will be continued in different institutions. As to the symbolic value of diversity, well, this is a free, shameless marketing. I published a book on who is the judge, identity and diversity on the international bench. So that that contains the extensive answer to your question. I do think I'm always very hesitant to talk about democracy and judges. The judicial system is not democratic. That's why we have parliament. I don't think judges should be elected or should reflect democratic winners of elections and things like that. I think two things are important when it comes to diversity. One is, do you get another decision if you put different judges on a court? And two is, do you get better or more or less compliance depending on who has rendered a judgment? And those are the only, in my view, the only two things that matter. But you are right, of course, that gender and nationality is more of a yes-no question. It's more difficult with regard to religion, it's more difficult with regard to political opinion, it's more difficult with regard to a number of other identity factors. Another one is legal education, for example. There was a study that showed that of all investment arbitrators, the 50 most appointed ones, 35 had a link with Cambridge University. Now, these people may have different nationalities, but if you've all been trained, or 35 out of 50 have been trained at the same university, that will steer your legal thinking. And I think we should, that's another argument in the book, I think we should encourage people being trained in different jurisdictions just to provide this diversity in legal thinking. So yes, religion is more fluid, it's invisible, but I think, like legal education, religion may well be more influential on how you reason as a judge than nationality or even gender. Last question, is the idea that you have many judges on a court that sort of cancels out identity? Yes, I think that's the intention. Does that happen in practice? I very much doubt that. I think first of all, there's courts where there are not that many judges. Not everybody is the ICJ, where you have 15 judges. If you look at arbitration panels, you've got 3, which doesn't cancel out a lot. But even among a bigger bench, you have voices that are considerably more influential than others. So I think in practice, to some extent, there might be some cancellation, but I think the identity of the judge, who is the judge, still matters very much. Thank you.
Grazie a Beatrice e a Freya. Questo conclude la sessione di diritto internazionale. Prima di dare la parola al Presidente Luigi Lacchè, da parte mia un ringraziamento. Siccome si parla di religione, ogni volta che si termina una giornata gentiliana ho la sensazione del miracolo, nel senso che si riesce ogni volta a creare un dibattito di alto livello e a produrre un evento con risorse che sono le risorse che offre San Ginesio e con le risorse che chi si occupa dell'organizzazione mette a disposizione. Però questo mi permette anche di ringraziare molto rapidamente veramente la comunità di San Ginesio. Se c'è qualcuno che non crede nelle attività del centro studi, per come dire, rinforzare la fede nell'attività del centro studi, io vi dico soltanto che mi capita sempre più frequentemente di incontrarmi con persone che non conosco, che sono avvocati, funzionari di organizzazioni internazionali, nella maggior parte dei casi ormai professori, che mi dicono: professore, si ricorda di me? No. Sono quello che ha partecipato alla seconda edizione dell'incontro di dottorandi a San Ginesio. Mi ricordo ancora quella lezione del professor Panizza. È una cosa che a me emoziona ogni volta che succede, perché ormai c'è una vera generazione di studiosi in diritto internazionale che sono passati per San Ginesio e che riconoscono tra momenti formativi della loro carriera l'aver speso 3 giorni a San Ginesio. Credo che questo sia veramente un piccolo miracolo al quale mi viene da pensare, guardo anche ai miei colleghi, ma non sarebbe forse bello cercare di portare, e qui Pepe trema, non sarebbe bello di cercare di portare anche i dottorandi di storia del diritto, di relazioni internazionali, di storia del pensiero politico, cioè di ricreare una piccola comunità che va un po' anche oltre il diritto internazionale, cioè con il diritto internazionale, grazie anche all'aiuto della Società Italiana del Diritto Internazionale, siamo stati capaci di farlo e considero questo un elemento, perché vedere poi i giovani che crescono, che diventano docenti universitari, che mandano i loro allievi a San Ginesio è veramente emozionante. Credo che potremo lavorare anche in questa direzione. Ripeto, questi sono Tutto questo riusciamo a farlo anche perché c'è qualcuno che durante tutto l'anno lavora a questi eventi, e io guardo Pepe Ragoni perché lei ogni volta mi dice sono stanchissima, però ogni volta io la vedo energetica e piena di vigore, e io mi attendo che per i prossimi 30 anni ancora, Pepe, bisognerà che tu rimanga così. Quindi grazie a tutti quanti, e do la parola al Presidente, all'amico Luigi Lacchè.
Beh, poche parole, siamo abbastanza stanchi e quindi non voglio aggiungere cose a quelle ottime che abbiamo sentito. Innanzitutto i ringraziamenti dovuti a chi come sempre consente di venire a San Ginesio, di soggiornare splendidamente qui, e quindi ovviamente Pepe Ragoni per prima, i nostri soci e amici del centro che collaborano in maniera così positiva e fattiva all'organizzazione di queste iniziative. E Paolo Palchetti diceva è come il miracolo di San Gennaro, no? Quello accade 1 o 2 volte l'anno quando accade, quello di San Ginesio accade ogni 2 anni, no? Perché c'è questa biennalità, anche se stiamo andando verso il miracolo di San Gennaro, perché la giornata 19ª c'è stata l'anno scorso e questa 20ª, quindi abbiamo fatto il miracolo per 2 anni consecutivi. In che consiste il miracolo di San Ginesio? Consiste nel fatto che si riesce, grazie un po' al clima, diciamo al contesto, all'ambientazione, si riesce a creare l'occasione per un dialogo diciamo effettivo, ecco, non esterno. Cioè ognuno degli intervenuti cerca di entrare nella lunghezza d'onda, gli storici degli internazionalisti e viceversa. La domanda che ha fatto ieri Beatrice indica perfettamente questo spirito, perché coglie in fondo il bisogno di dialogare, cioè il diritto internazionale ha ovviamente una sua dimensione contemporanea, ordinamentale, formalizzata, che può prescindere dalla dimensione storica, perché è autosufficiente, vive, come dire, del suo, ma noi sappiamo che in realtà, e il tema di quest'anno proprio lo dimostra in maniera molto chiara, cioè un tema come questo richiede questo dialogo. E il rischio qual è se uno non dialoga? È che il tema della religione nel diritto internazionale contemporaneo rischia di essere staccato da questo lungo processo storico, cruciale nella prospettiva eurocentrica. Ieri Alessandro Colombo ha ricordato questo aspetto, cioè la secolarizzazione, come dire, fa parte del patrimonio euro-occidentale, principalmente, cioè non è una chiave di lettura per il mondo globale. Quindi, secondo me, questo è stato un aspetto molto importante che è partito dalla relazione di Alberto Clerici, che ci ha portato dentro il 500 delle guerre civili barra religiose, partendo dalla secolarizzazione, dal tema teologico-religioso, che ovviamente va affrontato attraverso le interpretazioni storiografiche, perché c'è tutta una enorme letteratura, un'evoluzione della riflessione sul tema della secolarizzazione che, lo diceva anche Luca Scuccimarra ieri, che va ripensato. Non possiamo fermarci ad alcuni, chiamiamoli classici, no, della riflessione novecentesca sulla secolarizzazione. Quindi c'è bisogno di riflettere di più. E la religione di Gentili ci fa vedere che nel Cinquecento è un tema costitutivo, direi antropologico, cioè in quegli uomini non possiamo facilmente distinguere le diverse dimensioni. Poi noi diciamo la politica, diciamo il diritto, diciamo la religione, diciamo altre sfere, ma in realtà queste sfere sono inestricabilmente intrecciate fra di loro. E quindi, come dire, per affrontare temi come questi bisogna avere coscienza della complessità del tema. Cioè, poi abbiamo bisogno di cercare di separare queste sfere, perché ci serve per cogliere poi le facce di queste diverse dimensioni, ma poi nella realtà queste stanno assieme. E quindi questa dimensione costitutiva, Vincenzo Lavenia ci ha fatto vedere come in fondo una vicenda, no, apparentemente lontana dei Maccabei diventa un grande paradigma nella lettura, quasi una specie di struttura che parte dai Maccabei e permane del conflitto religioso, no? E come questa vicenda che lui ha ricostruito in maniera raffinatissima, come fa Vincenzo, che appunto fa vedere questo topos, questo paradigma degli zeloti resistenti e dell'uso poi strategico, strumentale, spesso, che è stato fatto, no, di questa vicenda, perché appunto può servire per ricostruire il tema del conflitto, cioè che significa il conflitto religioso, come si articola, come si declina, quali sono i termini del conflitto. E infine nella sessione, diciamo, degli storici, Giovanni Minnucci, mi spiace che sia andato via, ci ha fatto entrare davvero nel laboratorio, chiamiamolo oxfordiano, di Gentili, cioè in anni cruciali per Alberico Gentili, perché sono gli anni durante i quali pubblica il De Iure Belli, e sempre di più si capisce che il De Iure Belli nasce esattamente dentro quel laboratorio. Anche qui il rischio, no? Noi leggiamo questi grandi classici un po' staccandoli dai loro contesti storici e molto, come dire, precisi, come nel caso di quello gentiliano e della polemica con John Reynolds. Lo slogan formidabile, no, del Silete Theology Munere Alieno, che ha avuto questo straordinario successo, è stato preso dal De Iure Belli. Poi Giovanni ci ha fatto vedere che in realtà esistono altre formule anche più articolate dello slogan, chiamiamolo principe, e quindi una volta che viene portato fuori dal contesto, viene staccato, il rischio è quello di usarlo un po' come si può, o portarlo alle estreme conseguenze come quasi una visione del mondo, no? Come fa Schmidt nel Nomos della Terra, cioè lo porta in un contesto completamente nuovo e diverso e da lì parte per la sua analisi. Per cui, ecco, se non altro gli storici ci ricordano quanto sia importante entrare analiticamente nei contesti e quindi cogliere i termini precisi del laboratorio gentiliano. Tutti i rimandi interni, il De Nuptiis, con tutti questi echi che ci ha fatto vedere con il De Iure Belli, con le opere precedenti, quindi è un fatto molto importante. E quali sono, secondo me, i due temi che emergono con grande forza, un po' rileggendo Gentili con queste coordinate? Uno è ovviamente l'avversione integrale di Gentili per l'uso teocratico della religione. Quando la religione diventa instrumentum regni o peggio strumento di oppressione. Diventa una forma di violenza perpetrata su altri uomini. E quindi questo è il primo grande tema. Il secondo grande tema, pure emerso secondo me bene, sia nella relazione di Giovanni che poi nelle repliche, il tema che è così importante di questo dibattito tra che cosa fa il teologo e che cosa fa il giurista, che appunto è un tema molto importante, nel senso che è in fondo una tensione per l'egemonia della governance, forse si direbbe oggi. Cioè chi tra queste due figure, no, di intellettuali, che sia il teologo che il giurista, ovviamente sono, come dire, due tecnici, ma sono due intellettuali. E quindi che hanno una strumentazione, però c'è tutto un terreno comune. I teologi quasi sempre sono anche giuristi. I giuristi, a loro volta, alla Gentili, sono teologi. L'abbiamo visto ieri, no? E quindi questo... ma qual è la differenza? Che il teologo giurista guarda il mondo per dominarlo in un certo modo. Il giurista teologo, alla Gentili, guarda il mondo per, come dire, attraversarlo attraverso la dimensione, secondo me, umanistica di Gentili della civilis sapientia, cioè l'idea che il diritto è uno strumento di pace, non è uno strumento. Mentre la religione rischia di diventare uno strumento di violenza, si presta straordinariamente, perché discrimina, può discriminare, può diventare davvero, e perché è uno straordinario elemento identitario. Il diritto non è uno strumento identitario. Non ha queste caratteristiche, potrebbe diventarlo, ma non ha questa caratteristica. E quindi il diritto, se tu guardi il mondo attraverso questa chiave di lettura, ricerchi degli equilibri. Quindi questo conflitto in realtà è un grande conflitto che apre la modernità, perché per certi versi arriva sotto magari spoglie diverse, arriva fino a oggi. E vado rapidamente. La seconda sessione, che è iniziata ieri con Alessandro Colombo, già accennavo le diverse indicazioni che ci ha offerto Alessandro, proprio a cominciare dall'analisi critica del concetto di secolarizzazione, cioè ci ha ricordato che sì, certamente c'è una linea di secolarizzazione nell'Occidente, ma Westfalia non distrugge, come dire, il fattore religioso. Il fattore religioso resta in campo. E quindi questo è questo tema che ci ha fatto vedere da vari punti di vista, dal punto di vista dell'identità, l'identità delle nazioni, nation building, identità dei popoli, il tema al quale forse neanche ci verrebbe in mente della decolonizzazione, no? Quanto è stato importante questo processo, il fallimento prevalente del fenomeno, quanto poi abbia inciso quando abbiamo cominciato a capirlo, no? Sugli assetti delle relazioni internazionali da un certo momento in poi. Quindi un contributo veramente di grande interesse che ha legato anche la parte storica e la parte, diciamo, di oggi delle due nostre amiche internazionaliste. Ecco, se c'è, credo, un merito di questa giornata è che abbiamo, tra virgolette, costretto gli internazionalisti a riflettere su questo tema, no? Perché appunto, come è stato osservato, è un tema poco considerato, in fondo, no? Tra i 1000 aspetti del diritto internazionale non si pensa immediatamente, perché appunto qual è in fondo l'idea fondamentale? Religion doesn't matter. No? Questo è, diciamo, il punto naturale di partenza. La religione in fondo non conta, non deve contare, quindi c'è un dover essere nel diritto internazionale che, se si mettesse a considerare la religione, ovviamente quasi verrebbe meno, no? Al suo statuto. In realtà però religion does matter, e l'abbiamo visto da diverse angolazioni. Significa questo che la religione nelle sue 1000 sfaccettature determina l'indirizzo del diritto internazionale? Ovviamente no. Però ci sono dei temi di tensione, no? Dove ci stanno degli snodi dove il tema riesce fuori. Quindi abbiamo visto questa linea, secondo me, molto originale e innovativa di Freya, cioè capire che fanno innanzitutto i giudici internazionali, no? Che stanno dentro delle istituzioni, ma sono uomini, no? Perché appunto noi siamo abituati ai giudici nei sistemi nazionali, no? Dove c'è il multiculturalismo, in alcuni casi il multilinguismo, no? Perché ci stanno... Però certo a livello internazionale questo aspetto emerge in maniera enorme, no? E quindi che significa che i giudici possano avere una determinante religiosa, no? Quindi è un tema che secondo me va ulteriormente sviluppato, approfondito, molto difficile, no? Perché poi cogliere, entrare dentro le corti, entrare dentro il ruolo dei giudici è difficile, però è un tema molto importante. E infine Beatrice Bonafè in realtà è andata molto oltre il titolo del suo tema, perché ha dedicato la parte, chiamiamola introduttiva, a riflettere sul rapporto tra religione e diritto internazionale. Quindi credo un po' stimolata anche dal contesto. E poi ci ha fatto vedere quali sono i percorsi, i grandi campi, no? I diritti umani. Si protegge la religione in quanto tale? No, si protegge l'esercizio libero del credo religioso. E però sappiamo quanto poi questa dimensione possa sfociare verso, diciamo, delle forme che non sono esattamente corrispondenti a questo tema, no? dell'equilibrio tra religione e diritto internazionale. E poi i crimini internazionali, il genocidio. Sappiamo che, non dico sempre, ma molto spesso, alla fine ci sono temi religiosi, conflitti religiosi, o ci possono essere conflitti religiosi, quindi abbiamo visto anche un po' di casistica. Quindi personalmente ritengo riuscitissima questa 20ª edizione e quindi coroniamo questa data del 20º, secondo me molto molto bene. Avremo gli atti, quindi la pubblicazione delle relazioni, quindi consentiranno agli autori, come dire, di valorizzare anche questo dialogo, questa dimensione di dialogo, e sicuramente fra 2 anni avremo gli atti e avremo l'occasione per tornare a discutere, e quindi mi piace ancora ringraziare un grandissimo amico mio, ma del centro, Paolo Palchetti, e un altro grandissimo amico mio e del centro, Luca Scuccimarra, che come sempre, pur non essendo relatori, sono venuti, hanno presieduto e hanno amministrato perfettamente i lavori. Quindi grazie a tutti, andiamo a vedere questa piccola mostra di Nino Ricci e poi andiamo a pranzo. Grazie a tutti.